Now, our discussion today is all about a lawyer's role in conflict resolution in the Philippines. As an introduction, my journey towards ADR started when I became a lawyer out of curiosity, and then when I I have been exposed to contract drafting. The interest to learn more about ADR becomes more prominent. And just a disclosure, I am also a neophyte in ADR, but in order for us to recognize the value and the importance of ADR, allow me to give some introductions, certain concepts involving ADR, and the certain processes involved in the Philippines. So, as a lawyer, to be able to have this understanding about what are the available processes outside court is key to helping your clients even prior to um, having a dispute. So it's actually wise and helpful for your clients and also for those people who comes to you for assistance, that you know the concept of ADR as well as the available mechanisms, especially here and for us, especially here in the Philippines. Now, let's start with the discussion as to what is alternative dispute resolution. So, when you talk about ADR, the first thing that comes to mind is it should be voluntary, meaning the birth of an ADR, it comes from the agreement of the parties, such that the powers that transcend from the creation of the arbitral tribunal, the mediation, the processes itself, is birthed from the actual voluntary agreement. That's why there are dispute processes that are mandatory or required by law. This, by definition, is not a technically form of ADR. Meaning, if the mechanism is actually governed by certain law or imposed by certain law, then these are not true ADR. Because when you say through ADR, the creation, the processes, including the powers of the arbitral tribunal, including the mediators, are actually sourced from the agreement of parties. So that is the concept that we are to introduce now before we tackle the more concepts in detail. Now, there are three most important ADR. One is mediation, second is conciliation, and the other one is arbitration. Now, like I said, all of these ADR mechanisms are sourced from the actual agreement of parties, because if the parties do not voluntarily agree to avail of these mechanisms, then there will be no mediation, no conciliation, no true arbitration. Now, mediation and conciliation are almost the same as compared to the arbitration, such that mediation is the role of the mediator facilitates communication, negotiation, and assists in reaching a voluntary agreement. So you see in mediation that the role of a mediator is actually to put parties together, to allow them to coordinate in order for them to reach into an amicable settlement. Such that conciliation also is almost the same as mediation, but only that in conciliation, in mediation, while the role of the mediator is more active, here in conciliation is it's not as active as mediation. And this differs in arbitration because the neutral third party are not supposed to facilitate communication and negotiation. Why? Because one requirement of an arbitrator is you have to be impartial. And aside from the role of the arbitrator versus the role of a mediator, the arbitrator actually sort of act as the judge but although the setting is outside court. So that after the several processes, the product of arbitration is your award. So the award is almost equivalent to the court decision. So based on the evidence that you submit in during arbitration, the arbiter or the arbitral tribunal is going to render an award. And so as per definition, I actually would like to quote the most notable practitioner in ADR, attorney Valderrama. He actually searched for the actual definition of arbitration, and he looked for the definition in some cases, such as in ABS-CBN that was in the Philippines. This is a case in the Philippines that was uh, rendered in 2008. There was actually a misnomer or misconception about arbitration, meaning the arbitral tribunal was actually lumped together with the instrumentalities of the government. Now, as mentioned, I said that the arbitration or the arbitral tribunal is source its power from the contract by the parties as voluntarily agreed. Now, if you lump it together with the instrumentalities of the government, then it's not the arbitration that we were talking about. Now, also in Lanusa, he also quoted this one that it was described as a private process operating extrajudicially with litigation. Yes, that's instructive, but it doesn't really tell what is really an arbitration. Now he searched another definition coming from the model law, Article 7. And it says there that it only covers the definition of arbitration agreement. So it's just an agreement by the parties to submit to arbitration. Now it does not really give the full view as to what is really arbitration. Now, finally, he found this French definition of arbitration, and this describes in full what is really arbitration. Now here, as per French definition, an arbitration is the device whereby the settlement of a question, which is of interest for two or more persons, is entrusted to one or more other persons. So those are your arbitrator or arbitral tribunal, who derive their powers from a private agreement. Now, it is very important to know what is really arbitration in order for you to know what is the role of the lawyer. Because here, when it comes to arbitration, in order for you to have a successful mechanism to arbitrate, the agreement to arbitrate must be also effective. It must be valid and enforceable. So we just realize how important is the lawyer's role in actually drafting the contract. Because if you provide a defective contract to arbitrate, then it will pose problems for your clients. So it is important that as a background, what is really the purpose of arbitration. Because with that, you make sure that your clients are well protected and your clients' interests to arbitrate are really made effective in times when there is a dispute. Now, of course, the arbitration that we are talking about here is commercial arbitration, because there are some exclusions, especially in our jurisdiction. Because, for example, if it involves family disputes, then you cannot agree to arbitrate on those matters, because there are subject matters that are excluded by law. Now, this is how the interplay of laws in the Philippines look like. We do have several laws for ADR. So imagine if you are exposed in the jurisdiction and you do not know the interplay of laws, then it will be difficult for you to understand where to look at, what to apply. And for me, although I am not an experienced arbitrator, I would say that least an understanding and an overview of the legal concepts would actually help the lawyer in helping his clients. Now, the legal framework in the Philippines is we do have this old law. We do have this Republic Act 876, and this is a arbitration law of 1953. And later on in 2004, there was this ADR Act that is passed in 2004. But instead of consolidating all laws, what this ADR Act did is just incorporates by reference the domestic arbitration law, the uncitral model law, as well as it provides a procedural aspect for the New York Convention. So you see, you have to look into several cases in order to know what to apply and how you're going to understand the interplay of laws. But rather, for short, there are certain laws that are involved, quite involved in the Philippines when it comes to ADR mechanism. But the goal here for us is not to confuse, but rather to shed light on the matter, not to make us an expert, but rather to have this at least understanding as to the interplay of our laws, of certain laws in our country. Now, in the what is this uncitral model law? The purpose of this law, from the word model, it seeks to, it seeks to reform and modernize local arbitration and make it at least uniform and consistent with each other. And like I said, our law, the ADR Act of 2004, uh, incorporates by reference the uncitral model law. But how will you know which of these laws actually apply when you are faced with a dispute and there was this request, there was this clear intention to arbitrate. Now, again, this is not the way it's not the intention of this is not to discuss the nuances, but to give you at least an idea. The first thing to have to identify is to determine first if the dispute is actually local. And when you say local, the actual arbitration clause is clear that the arbitral that the seat of arbitration is the Philippines. So that you will know that it is local. It is local. And if it is local, you have to know also whether it is domestic or international. So if there are foreign elements, that makes it international. And you know that the uncitral model law will apply. And if it is domestic, then RA 876 will apply. So meaning, it is very important to know first what is the seat of arbitration. The seat of arbitration is actually the place of arbitration, but it does not refer to the place where you do your arbitration. The place of arbitration is equivalent to the jurisdictional seat, whereas the place where you do your arbitration is actually the venue. So I think that's clear. And after determining if it is local, then you identify if it is international or domestic dispute. Then you know which law will apply. So there are some requirements in order for you to know if it is international arbitration. But one thing that you can remember, if the place of business of the parties involves several states, meaning countries, then that dispute is actually international. And in arbitration, there is what we call institutional and ad hoc. Institutional, meaning you refer your arbitration to the rules of an institutional arbitration. Meaning if, for example, the SIAC, the Singapore, you have this Hong Kong institutional arbitration centers. That is the institutional arbitration. Whereas when you say ad hoc, the procedures, the how you're going to select your arbitrators are actually entirely left to the parties, meaning you are free to stipulate how you're going to do your arbitration. And if you are to ask several experts on that, of course, they would say that it is always wiser to use institutional arbitration, such that they already have this standardized rules. They already know the interplay of the parties. They do have facilities, and you also avoid the problem in actually in agreeing who will be the arbitrators or the tribunal. So it will pose several problems if if you select to do it yourself or ad hoc arbitration, and then you do not have enough background on arbitration. That's why I've been saying that you need not be a practitioner uh, on ADR. You need not be an arbitrator. You need not be an actual active participant in ADR processes for you to learn on learn on ADR, because here it's either it will make or break the case of the client, or their choices in whether going with the ADR or just choosing litigation. Now, I'd like to promote at the same time the the arbitration center in the Philippines, which is PDRCI. And if you are to look at the background of the arbitrators, the trained arbitrators, you will know that these people are actually having actually those who have 50 years, 40 years experience. And there are 80-year-old people, 90-year-old people who are actually practicing arbitration or ADR. So you know that they are competent, and you know that they know what they are doing. And also there are several arbitral institutions also in Asia as well in Europe. So you can look at it if you want to know several institutions within Asia also, aside from the Philippines. AIAC is in Malaysia, Kuala Lumpur. Before it was KLRCA, now it is AIAC, and of course the PDRCI. You also have the SIA from Singapore, and we do have one in Hong Kong. And also, to choose which institution, also you have to consider the language, because if you choose a different language, then all the proceedings would be translated. That's why it is important to consider also who are the parties involved, which country are you, if it is accessible to both parties. So those are the things that you should consider when putting in your arbitration clause. Now, of course, we now compare litigation from arbitration. Like I said, the arbitration is a byproduct or a byproduct of the agreement of the parties. Whereas in litigation, the court is created by law, and the jurisdiction of the court is conferred by law and not by agreement by parties. So it's totally opposed to ADR or arbitration. And also, aside from that arbitration, the arbiter is the one who handles the proceedings. Litigation, it is the judge who actually handles the dispute. And in litigation, we do have the rules of court, the rules of evidence, which are very technical, they're very rigid, and you have to follow those. Unlike in arbitration or in ADR, you have, because it follows the principle of party autonomy, then you can agree on the procedure, you can simplify it, including the adjudication process, including the reception of the evidence. So it is more flexible, a lot friendlier, and you can fit into your needs also. So that is the difference between litigation and arbitration. And I would say that litigation is a compulsory process, such that you cannot decide among yourselves which court to go to file, which court should hear your case. It depends on the jurisdiction of the court. Whereas in arbitration, because it is about party autonomy, then you can agree where, when, and how you're going to arbitrate. Now, this is the most important part, the arbitration agreement. Uh, we should understand, because we have students also here, and we have several practitioners who are not so into ADR. The arbitration agreement should be thought as different from the actual contract itself, such that there is the main agreement, but there is also this arbitration agreement, your agreement to arbitrate. And there it could be in different forms, meaning you can put it in a clause by reference, you incorporate it by reference, or you can have a separate contract to arbitrate, or it could be in any other form, provided that the clear intention to arbitrate and the incorporation by reference is actually clear. So, like I said, our role as lawyers are really to be learned in the practice, so that we know what clauses to put, or whether we would suggest parties to go into arbitration or go into litigation. Now, the first requirement for an arbitration agreement is that it should be in writing. Under the New York Convention, each contracting state shall recognize an agreement in writing. Now, in the model law, in the 1985 version of the model law, the requirement that the arbitration agreement should be in writing. But in 2006 version, it allows unwritten agreements. However, in the Philippines, we have not adopted yet the 2006 version of the model law. Therefore, we applied the 1985 rather, the model law, which requires that the arbitration agreement really be in writing. Now, in drafting arbitration agreement, like I mentioned, you have to stipulate the place or the seat. The place or the seat is not the place where you conduct your arbitration. The place or the seat is actually the seat of jurisdiction, or the place of arbitration, or the seat of arbitration. And therefore, if it is domestic arbitration based on the seat. For example, the seat of arbitration should be in the Philippines. So that makes it a domestic arbitration. And of course, the law. Like I said, when you draft a contract, the arbitration agreement is not the actual agreement in main. Meaning, like for example, you have this franchise agreement. The law governing the franchise agreement is different from the law of the arbitration agreement. And of course, you can also stipulate the number of arbitrators and the language, because the language will actually be very important and significant. Because imagine translating every document, for example, if it is involves parties who actually speak Chinese, then the consideration really is to choose which seat really when you select your arbitration, because arbitration is not just a simple copy paste of the arbitration agreement. You also consider the seat of arbitration, the law that will come into play, including how your arbitrators are going to be selected. So that will be the choices in drafting arbitration agreement. Now, I would like also to give a little bit of discussion on pathological clauses. We are not to discuss each pathological clause right now, but it is just an emphasis as to how a lawyer can make or break the intention to arbitrate. Meaning, if you insert or put an arbitration clause, and if it is pathological, then the intention to arbitrate may not be successful because it creates confusion, and the intention to arbitrate is not really clear. That's why it is not just a matter of copy paste as to the intention to arbitrate, but rather you should have at least an understanding on the ADR mechanisms and the interplay of laws, whether it will be beneficial for you in the future, especially if the jurisdiction is it friendly for ADR or not. So that's it for pathological clauses. Because also pathological clauses would mean that the arbitral agreement will not be valid and will not be enforceable. So instead of going into arbitration, then there is a tendency that parties will just go to court to do litigation. And there was this senior practitioner who was asked, how do you really, can you help me draft a clause for arbitration? And this is what he said: I cannot really cover everything and teach you how are you going to draft the arbitration clause, because it takes a lot of it takes a little, at least a little understanding on the arbitration. So he said that, oh, why not you attend a seminar on that and understand the ADR mechanism in order for you to create and draft an effective arbitration clause. So that's a quote unquote from an established arbitrator. Now, of course, like I said, it's more safe to use institutionalized arbitration, such as you can use the model clauses, because there it is covered. Yeah, the seat of jurisdiction. How are you going to handle the dispute if it is not if it is not resolved given the time frame? And you have this model arbitration clause, and you will see. And for those who have already wide range of experience in drafting, then these clauses are not new to you. So normally the standard number of arbitrators is one or three, and the selection process or the appointment of arbitrators are actually provided under the rules of the institutional arbitration that you selected. And of course, the reason why we have to understand these mechanisms is, of course, to have a valid and enforceable arbitration contract. Now, this is the part that I would like you to have a view as to how is the ADR mechanisms uh, is if, embedded in the Philippines. Like I said, it will only be considered as a true ADR or true arbitration if the processes, the selection process, including the agreement to do ADR, rests solely on the parties. But if it is compelled by law or if it is compelled by rules, then it is not a true ADR. In fact, in labor cases in the Philippines, you cannot do, it is not allowed to have applied the true ADR, because these are one of the exceptions. You have to go through several processes in the National Labor NLRC, Labor Relations Commission, in order for you to settle disputes involving issues on labor. And One good thing is that if, for example, there is a labor case, the each of the departments or the administrative body has its own rules on how you are going to, because in labor there is a mandatory, there is what we call single entry approach or sena, meaning you have to undergo two separate schedule of mediation processes before it will ripen to an actual dispute. So we can appreciate here that even in quasi judicial or administrative bodies, there are a lot of mechanisms that are involved in order to prevent, in order to encourage uh, compromise by encourage a settlement by parties. And even agrarian cases involving land disputes on agrarian lands, they do have mechanisms. But again, these mechanisms are not actually the true IDR, because these are imposed by law or by certain rules. Now, if you look into our judicial system, and for those who are not from Philippines, uh, for small, for cases that are not in, that does not involve serious disputes, or for example if the crime involves a penalty of 1 year or less, then it has to go through this what we call barangay conciliation proceeding. Barangay is really the smallest political subdivision in the Philippines. And before you go to court, it is actually a requirement for you to have undergone all this, in order to siphon out the, disputes which are, and so that the court dockets will be unclogged, because really there is really a lot of burden for courts to unclog court dockets, because there are a lot of cases filed daily. Now, interestingly, this is actually an actual experience by my partner. uh, he actually used this mechanism, that is an agreement to submit to mediation. Now, this is not, there is no case actually filed in court. What they did is to apply it to a mediation. It's not from any institutional mediation center, but rather another mechanism involved in court, wherein you agree to submit to mediation, and the product, which is the compromise agreement, would actually be, if there is a, for example, you do not comply to the agreement, then it will result to a legal intervention. So instead of going into the most rigid court practices, such as you file an action in court, you file a case, then you can easily seek legal intervention by filing a petition for enforcement. So meaning this will just lead you to one court hearing, and then you can enforce what was actually agreed. So this is an interesting feature, wherein if it involves not so many huge millions of pesos or US dollars, then this is an option for you to save time and money and effort. So it's easier. It involves court intervention, but uh, it is not as technical, or it does not involve a lot of time. I think I would let Czar talk on this matter, because this is his actual experience in court. Now
Yeah,
we have, yes,
yes, Attorney Leo, you may proceed. Or can I share my experience?
yes. Can you just to break the the monotony?
Yes. Yes. To start with, as a lawyer also by bank, we have a lot of collection cases. More so that we are in the time of pandemic, so a lot of loans are turning sour. A lot of corporations filing rehabilitation proceedings, or liquidation proceedings, and so um, there are also, I mean, the demands for filing cases, is piling one after the other, and so we have to think, which remedy that we can use in order for us to recover the amount lent in a way that we will also not be paying more for purposes of the litigation expenses, or not paying at all. And so um, we come across this mediation um, provision under the Alternative Dispute Resolution Act of 2004. So basically, this is just an agreement between the parties to submit to a mediation, or to enter into a mediation. And the product of that mediation is a so-called compromise agreement. Now, the ADR Act of 2004 provides for an uh, enforcement process wherein such compromise agreement will be deposited to the clerk of court, where either the parties reside, and in case of breach, one party may file a summary petition for enforcement. And so, as you can see, you need not um, file a case or start with sending demand letter, file a case, and then go to the motions of the pretrial conference, trial, presentation of evidence, execution of judgment. Because this process, is in a way shortened your process of collecting the money, so um, the cost relating to this is only minimal cost to be paid to the professional fees of the Supreme Court accredited mediator, compared to the filing fees that you will be paying before the courts, depending on the amount sought to be recovered. So, interestingly, in the Philippines, only a few lawyers will explore this procedure, probably because, on the professional fee side of the lawyer, where if there will be no trial, or series of trial, probably clients, there is no also payment for the appearance fee to the lawyers. So, but on the part of corporations such as banking, it will save a lot of cost, on the part of corporations. So this procedure may be also incorporated in any agreement by the parties. So, yeah, that is just a bird's eye view of that mediation process, wherein parties may agree to enter into a compromise agreement, and such compromise agreement will be deposited to the courts. And in case of breach of any provisions, the offended party may file a summary petition for enforcement. So very short proceedings, and very cheap, as regards the payment to as regards the litigation expenses. So that's
Thank you.
it, Attorney Loueli.
Thank you, Attorney Zar.
Thanks
We
as
have to
well,
do
Attorney
that in
Loueli.
order to break the monotony, and also you will also appreciate that these are actually real experiences, and we do find means for our clients to make it as fast and then efficient as possible. Thank you for that input, Attorney Zar. So like I said, there are embedded mechanisms in court, as well as some quasi-judicial or administrative bodies. As long as these are not one of those excluded by law, because civil status of persons, marriage, legal separation, that you cannot agree to arbitrate, or you cannot do a compromise on that. You have to really go to court in order that your action or petition be actually granted. Now, like I said, we have several mechanisms in the administrative level. If we are faced with intellectual property dispute, then the IPO field provides for several mechanisms. Even they do require mediation for that. And of course, for labor cases, like I mentioned, the single entry approach, you have to undergo two mediation in order for you uh, to arrive into a settlement. And this will actually prevent the clogging of their dockets also. And also, it will speed up the resolution process involving labor cases. And then the same with the Department of Agrarian Reform and the barangay conciliation proceedings. Interestingly, the byproduct of the barangay conciliation procedure is actually would have an effect of like a case, an actual case that were actually adjudicated in court, meaning you can actually ask the body in the barangay to enforce such an agreement. And after the lapse of 60 days you were not able to enforce it, then you can actually go to court. And the nice thing about this is that it is not as it will elevate to a level of just mere agreement by parties or mere compromise to an actual to a same level, such as the court actually render the judgment. So that is what is very significant when it comes to the barangay conciliation procedure. And now for I think by this time we're able to at least have an understanding on ADR versus litigation. When it comes to speed, of course, we all know that the court dockets are actually clogged. Even the court itself imposed several mechanisms to prevent cases to actually ripen into a full-blown trial. In fact, we have this court annexed mediation, and then after the court annexed mediation, there will be another JDR that is administered, interestingly, by the judge, especially on cases that are just civil. So you will understand how the courts really have been working and imposing several mechanisms to avoid to going into litigation. And of course, when we talk about litigation versus ADR, we know that who actually resolves the proceeding, who actually resolves the dispute, such that if it is through a court, then a court has a general knowledge on the topic. Whereas if it is an ADR, you can actually select an arbitrator who is well learned in the practice. Because, for example, the construction arbitration, there are engineers, architects who are actually doing the ADR processes. So you can select who you think can better grasp the issues of the parties and render a fair and a more desirable judgment. And also, I think this was mentioned all throughout, the confidentiality. We all know that private corporations, when it comes to dispute, they would want to protect their reputation. And this is what is the most interesting part of ADR, because the processes are actually confidential. Meaning, if this involves financial issues, involves, for example, intellectual property, if this involves certain information that you do not want to go public, then ATR is a good choice for you. And of course, the one who is The one who plays a significant role is really the lawyer, because you will be, of course, the one who can advise your clients whether to go for ADR or not, based on practicality and the cost and the time. And I think this is the last slide. So we shall answer now the question: what is the lawyer's role in the ADR? Uh, of course, the lawyer is an advocate, and we are aware that like in here in the Philippines, and I think also with the several other jurisdictions, the courts are actually laden with cases, and this is how we practice it. Uh, the moment that a dispute comes into our office, we always assess: is it wise to go to trial, or is it wiser to arrive into a compromise such that the cost, the time, and the emotional baggages involved, especially when dealing with families, you have to consider that, and also assist in deciding whether to consider true arbitration or do litigation. Because if your clients are actually corporations and you want to resolve the issues fast, if ever there are going to be issues at hand, then you already have that tool to advise your clients whether to go for ADR or to just go for litigation. Because another consideration is, for me personally, is the: are you comfortable going into litigation, or are you more comfortable in availing such ADR mechanism? Because ultimately, ADR is always voluntary, but you have to know the interplay of ADR. You have to know if it works well for your client, or if it.
Excuse me. May I interrupt?
Yes.
Excuse me, may I interrupt? Sorry. My name is Christine Koo. I'm from Hong Kong.
Hi, Christine.
Hi. Concerning the fact that you are talking about voluntary, right? I don't know about the Philippines, but then in Hong Kong, if we are talking arbitration, and the arbitration is listed, is embedded in an agreement between the parties, then the parties must go arbitration. I mean, they can't go litigation directly. Otherwise, it will be thrown out of court.
Yes.
So arbitration is the first thing to do, unless the parties agree, okay, we discarded the condition of arbitration, we go to court directly, unless both parties agree to it. So that is, I guess, maybe a bit different, because in Hong Kong, you can't say, oh, I want to go to arbitration, so let's go. No, you have to look at your document, your agreement first. So that's point number one. Point number two, on those mediation, or what do you call the, on mediation. Mediation, on the contrary, in Hong Kong, more and more cases arise where the court require mediation before you go to court. Now, you see, for example, just a divorce case. You don't sign a mediation agreement to mediate not to get a divorce right before you get married, or you sign an agreement to say that we go arbitration. So what happened was, for all matrimonial cases where petition to divorce is filed, the court will, as of law, by law, order mediation. You, husband and wife, go to mediate first, and it breaks down, then you come back to court. That is exactly what the court is doing. So maybe a bit different, I guess, right? It's not all similar in all jurisdictions. Thanks for, and sorry for interrupting.
It's actually a good you raised that difference. But on point number one, actually, here in the Philippines, if you, based on the ADR Act, when there is, for example, there was a case filed, and then there is this prima facie evidence that the court realized that there is
Hello,
really
Claudio, restage.
this intention to arbitrate, then what will the court do is to refer it into arbitration and to stay all proceedings. Therefore, if the clear intention is really to arbitrate, then the court has nothing to do but to refer it to arbitration or any other ADR mechanism. And also, it's interestingly in the Philippines, like I said, we have under our civil code, uh, when it involves status of persons, for example, a marriage, legal separation, we cannot do ADR, we cannot compromise on that. It should be directly filed in court, and it is not part of the ADR mechanism. Quite interestingly, although we have also in legal separation, we have this cooling off period, but there is no such reference to ADR, availment of the ADR. Just a side discussion on that, those things that Christine raised. And I think for lawyers to be able for us to really know what's best, or to make an intelligent advice to our clients, is to really know the actual processes of ADR. Because if you are always into litigation and your view is like that, then you would not be able to appreciate some other mechanisms that might work well for your client, just like what Attorney Kabakang has discussed. And I think that will be the discussion. If you have any other inputs, perhaps from other jurisdiction, then we would love to hear from you. Thank you very much.
Thank you, Attorney Liu, for that knowledgeable insight. I think we can open the floor now for questions, and there have been a few. My colleague Joseph, who is from our Sales and Communication Department, can assist me on this.
Hi, everybody. Good afternoon, good morning. So the floor is now open for questions, and feel free to write down your questions on the chat box of your bottom right of your Zoom screen, and Attorney Loueli will answer your questions in real time. So we have here the first question. It's coming from Mr. Camthorn. What are the Philippines' reservations on enforcement of a foreign award?
Okay. Wow, that's very tough question. But for a foreign award, what our ADR Act actually provide is that our jurisdiction does not have the power to actually set aside an award. So it's either you recognize the award, or you refuse to recognize the award if it involves a foreign arbitral award.
All right. Does that answer your question, Mr. Camthorn?
For Thailand, the reservations are when the award is not in compliance with the legislation, or it is in contrary with the public order. So those are not enforceable awards. Do they have the same provisions, the same legislation in the Philippines?
In the enforcement, the application of the foreign arbitral awards, and you can just a party. I would like to read chapter 7 of the ADR Act. The party can the jurisdiction in the Philippines, when a foreign arbitral award is actually asked to be enforced in the Philippines, then there is no other way but to enforce it or to deny it. And I think, and it is the same as in Thailand, that if it is contrary to public morals, there are actually certain cases on that, then the jurisdiction will actually refuse to enforce. And
Okay.
yes.
Okay, thank you.
All right. Thank you so much, Mr. Camthorn. Second question will be coming from Mary Rose Baluran. Her question is, can a non-Filipino citizen be selected as an arbitrator?
Yes, quite interestingly, if you look at the ADR Act, it is what the ADR ADR Act provides is that you cannot refuse an arbitrator by reason of his or her citizenship. So you can actually agree on the citizenship of the arbitrator, unless the parties would agree that they want the arbitrator be Thai, Filipino, American. So that answers the question.
All right, thank you. And the third question is coming from Earl Roland. Uh, his question is, I am curious that there is a mediation process in the court. Why is that so?
Yes, like I said, the courts are laden with cases. So the courts employ several means for the parties to actually agree into compromise, so that of course there will be mediation or referral to mediation or the JDR. But what to kins consider when it comes to mediation in court is that, for example, there is already a case filed, and the same subject was referred to mediation, and the parties agree and reach a compromise agreement. So this compromise agreement will be judicially recognized, and this will be what we call judicial compromise. And this will in effect be equivalent to a court decision, so that if one party fails to comply with his or her obligation based on that compromise, then the party can actually ask for the execution in court. That is if there's already an existing case and there is a judicial compromise. Because if it is outside court and you reach a compromise agreement, then as per law, under the civil law, you either go back to your original agreement or you rescind the compromise agreement, and then you go to court, and that will be on a specific performance, so not execution, because you haven't go to court yet. So that is the concept and effect of mediation.
All right. Next question be coming from Mr. Naveen. Can two domestic companies can choose international arbitration?
And two domestic companies, I think it falls on the concept of party autonomy. So if you are ah can you repeat the question again,
Yeah, the
Joseph?
question would be, can two domestic companies can choose international arbitration?
Yes, of course you can. Are
Mm,
you referring to the seat of jurisdiction? So if there are two domestic companies in the Philippines, of course you can choose Singapore, Hong Kong, or
um,
other jurisdiction.
does that answer your question, Mr. Naveen? Oh, um, yeah, he's okay. Let's move on to the next question. I think that probably it answered his question. Next is coming from Mr. Theory. Is time limitation suspended by mediation?
Is that timers or limitation in your jurisdiction, you're referring to the prescription, the time
Yes,
limitation to file?
yes. If you are, I don't know if, for example, if there's a question of hidden defects. So if you start mediation before litigation, is a mediation process suspending the time limitation?
Uh, I think the answer to that question is when you go into mediation, it's actually falls the period wherein you can actually go to arbitration or to trial. So it's in a way suspends the time limit. I don't know if we are referring to that same time limitation.
Okay, thank you.
All right. We'll answer one last question. This coming from Miss Charmaine Cutales. Her question is, which is more effective, ADR or litigation?
Oh, that's a very it varies on the actual situation. Again, you have to consider the subject matter involved, the speed that you want to arrive, and the complexity of issues. Because if it is just a, for example, a 1 million peso dispute, then I would suggest just going into litigation. Or if you really need a quick resolve to the dispute, and you do want to have confidentiality on the issue because it is, you want to protect your company, then ADR would be a much better choice. And as a note also, in the Philippines, for example, the PDRCI, the filing fee is around 1,000 US dollars, and 2,000 with the extra expenses. Plus you pay for the 2,000 US dollar for the arbitrator. Now, if it is involved, if the case involved is, or the issue involved is just 1 million pesos, then I would suggest going into litigation, because I think you would, an estimate, you would just file a docket fee of what's 30,000. That's 600 US dollars plus your lawyers, and you don't have to pay for the arbitrator. So it varies on the goal as well as the issues involved.
All right. Thank you so much, attorney. We still have a lot of questions, but we will actually answer them back from the email. Giving it back to Angel. Angel?
Thank you, Joseph. Thank you, Attorney Lou. Thank you all for joining us today. I know we've just hit the hour, so I won't go over time. But I just want to extend a thank you to all the attendees who made it here. Thank you, Attorney Lou. Your insights have been really valuable, and I hope our audience get as much out of this discussion as I have. I just want to let everyone know that Asiajuris is open for new members. We also do run lots of webinars and in-person events soon, hopefully. So if you are interested or you have a question, feel free to send us an email at asia.juris@asiajuris.net, or visit our website at www.asiajuris.net. Our next webinar will be next month with the topic of redundancy during the pandemic and the new labor law of Vietnam. So details will be out soon. Thank you, and have a happy Wednesday evening to everyone in the Philippines.
Thank you.
In Asia.
Thank you.
Thank you so much.
Thank you.
Thank you.
Thank you.